As it happens, I spent 10 years working with one group, but at 4 different law firms in San Diego, where the IP community is fairly fluctuating. So every couple of years you go to a new law firm. That's just a thing that they do. So what I thought might be helpful is to come and speak with you a bit about what it means to have a career in intellectual property and how you go about getting such a career. I will tell you that I heard a very similar talk when I was in graduate school. The gentleman had gotten his master's in chemistry and was coming to talk about the benefits of being a patent attorney. And I sat for an hour and I listened to him talk, and I got up and walked away, and I thought, well, that sounds like a terrible idea. Literally, I said that. That's a terrible idea. So, fast forward 15 years, and in fact, that is what I did. And I wish I had paid more attention to what he had to say. Life is funny that way sometimes. So, I'm going to talk to you about where sort of my career development, with the caveat that it's a fairly unique path. It is not a path that 4 out of you can trace, in part because it played on going to a women's college that has a very strong alumni network. But you might be able to reproduce that with your own background. So, I have an undergraduate degree from Bryn Mawr, said Women's College, in chemistry and history. I went to Chapel Hill for my PhD work, and then after that went to San Diego State to do a postdoc. The postdoc at San Diego State lasted about a year, and then my advisor, who was a much better chemist than he was financial advisor, ran out of money rather abruptly and needed to encourage me to find other work. And so what I did was take on 3 adjunct faculty positions where I was teaching at San Diego State, which is a large state school. I was teaching at Mesa College, which was a small community college, and I was teaching at, the other one was the University of San Diego, which is a private Catholic college in San Diego. This was a terrible time for me. Being adjunct, you've probably read the stories about driving madly from one university to the other and trying to provide teaching support and office hours and all that stuff. I got that for a whole semester and thought, this is not what I want to do when I grow up. But you might also know that living in San Diego is fairly expensive, and so you can't live in San Diego without a job. So job searching was key in my time, the semester that I was doing this adjunct teaching. So there were a couple opportunities. One was investigating a teaching postdoc that the University of San Diego was offering. The other was considering more adjunct teaching. This was a bad choice, but I was fully open to that because I needed the money, right? And then the other was reaching out to women who had graduated from my college. And again, Bryn Mawr is a fairly small community. It graduates about 300, 350 women every year. So it's fairly tight-knit, and they're likely to help one another. And so I had reached out to a woman who had graduated years before, had gotten her master's from MIT, and was now working as an attorney at a law firm, and asked her what I might be able to do. And so she suggested that I come in for a lunch interview so that we could talk about, so she could see me, right? And so we could talk about what the career and what the position that she might have available would entail. Now, I will tell you that I'm old, and so there were things that I didn't have to worry about when I was thinking about getting interviewed for this position. I didn't have a Facebook page, I didn't have Instagram, I didn't have access to YouTube. So my opportunities to embarrass myself were limited to my immediate vicinity. And I also was mindful of trying to appear professional when I showed up. So I got out my business suit, it wasn't this one, but something very similar to it, and tried to put together a story, even for the lunchtime conversation we were having about how anything that I had done in the past could be tied to patent law, with the caveat that I had never actually seen a patent before. I hadn't done patentable research when I was in graduate school. I hadn't paid really close attention to that guy who was talking about being a patent attorney, but here was someone who was willing to talk to me about employment, and I was willing to listen. So, how did I convince this woman to hire me? And I love this quote by Longfellow that talks about when you think of yourself, you think of your potential. And a lot of good hiring HR kind of people recognize the possibility of potential. But a lot of what gets you in the door to sort of get that sense of potential is what you've done. What does your pedigree look like? What kind of boxes have you checked that might not be substantive, but do count, that lets your resume sort of float to the top. My resume floated to the top on her desk because it was the only one there, because there wasn't a position being advertised. I had just reached out to her. So that's sometimes helpful. If you find someone who's in an organization that has some connection to you, either attended your undergraduate institution or attended your graduate institution, or even better, worked in the lab, and you can say, oh, Dr. Desai, it's time for me to move on. What do you think about opportunities in your group that maybe aren't yet advertised or just being talked about? And so that sometimes can be useful. So when I sat down to talk with this Bryn Mawr alum, what I said was, you went to Bryn Mawr, I went to Bryn Mawr, we're really great. And what that degree said to her was that I was trainable. She knew what that meant in terms of the academic rigor and the training that I had gone through in terms of being able to think, but also that I could take instruction. The PhD that I got from Chapel Hill was really a union card. Nobody cares about the research. Even today, nobody cares about the research that I've done. I know a whole lot about this much of the world in the field of chemistry, right? But it shows that I'm stubborn. It shows that I showed up to lab. It shows that I learned how to teach myself new information, how to distill that information and communicate it in what we'll see is hopefully an effective way. And these are useful skills when you go out in the world. And a PhD and a master's can represent that training that you have. The other thing that was an advantage to this woman who was going to hire me was that it was very low risk, because if she didn't like me, she could just fire me. And I kind of thought when I walked into the interview that if I got a job offer, there was some length of time behind that I was going to have a chance. And my husband's postdoc advisor said, yeah, that length of time for you to make an impression is about 3 months. So, hit the ground running, do the best you can, because they'll just fire you. I was like, oh, God. Back to San Diego being an expensive place to live. So, intellectual property careers. There's actually a couple different things you can do and say that you're involved in intellectual property. And so I'm going to go through what those are and what kind of background lends itself to those titles. So the first is a U.S. patent examiner, and that means that you work at the U.S. Patent Office. You can show up on the doorstep of the U.S. Patent Office not having ever seen a patent before, not having much expertise in intellectual property. And depending on your technology background, they will be more excited or less excited to see you. So, for example, if you have a BS in chemistry, probably not so excited to see you, because us BSs in chemistry, they were kind of a dime a dozen. Master's probably a little bit more interesting. PhD, probably that much more interesting. If you're in a less crowded field, like electrical engineering, if you show up with a BS, they're probably interested in speaking with you. A master's for sure. PhD, they would wonder what you're showing up on their doorstep, because there's a lot of other places you can work with a PhD in electrical engineering and that sort of thing. And you can imagine the spectrum sort of spans between those. You're either closer to us poor chemists and biologists, or closer to the other end of the spectrum. And you can get the internal training that you need. The federal government's very good about training, and they will train you up at the patent office for the skills that you need. You will be closely supervised by someone who's been doing this a long time. You will show up at the U.S. Patent Office for at least the first 2 years, where you're working closely with a supervisory examiner who quality controls the work that goes out. The work that comes out of that supervisory examiner gets also quality controlled. you can imagine that's the government. There's a lot of checks and balances, and there's an active debate now as to the value of the patents that come out of the patent office, and so they're even more attentive to the quality of the work product that they put together. You can also be a patent agent, and that's in fact what I am. And a patent agent simply means that you sat for an exam that the patent office used to offer twice a year. I think now it's online and you can take it just about any time of year. But back in the olden days, it was an exam that was offered twice a year. And if you passed, you could, for the rest of your life, call yourself a patent agent. It did not require going to law school. It does not require continuing ed requirements. It does not require payment of dues. You get a number assigned to you, a registry number, and that number gets older. So when someone looks at my number and they go, wow, 51,000, like you passed a long time ago. And I said, yes, I did it. Well, you must be really good at what you do. Ironically, no, it just means I passed the test a long time ago, and you'd like to presume that there's been some, experience and professional development going on in there, but really no, it just means I passed the test a long time ago. Now, if I want to continue to sell myself as a patent agent, I do in fact have to demonstrate some ongoing knowledge of changes in patent law. And for example, President Obama really grabbed my attention because he signed the America Invents Act, and that does fundamentally change a lot of the ways that we prosecute patent applications and think about intellectual property development within the U.S. He did that after I joined A&T, and so I've been sort of watching it a step removed than when I was at the law firm, where you would spend a whole lot of time getting up to speed and becoming expert on that very quickly, because clients would come to you and say, I'm paying you anywhere from $200 to $500 an hour to be an expert, so, let's hear it. And again, the sliding scale of law firms that are likely to hire patent agents. If you are just, as I was, just a PhD in chemistry when you show up on their doorstep, they're probably not interested. My luck was that I connected with someone who had gone to my undergraduate institution, and she needed a scientific sidekick. She actually was in great need of someone who could spend a whole lot of time at the library looking through journal articles, finding a particular disclosure for a subject matter that was of interest to her, be it doing chemical structure searches, knowing what the spaghetti around organic backbones means. And I will admit to you that I am not an organic chemist, and the spaghetti is just a picture, but I convinced her that I could learn. Give me a review article, give me Google Scholar, and I can get up to speed so that I can have intelligent conversations with inventors about what their spaghetti means, and they can tell me, and I can translate that into patent lingo. So I was lucky, and so I ended up working for her for 2 years before the law firm that I was at said, as much as we like being able to bill you to our clients as a scientific advisor, it would be even better if we could bill you as a patent agent, which meant that they could charge more for my time. Correspondingly, it meant that I was going to get a raise, so it was in my best interest to take this exam. So I took time off to study for the exam, passed the exam, yay! And then got that 51,000 number that I can carry with me to the current day. You can also, if you have great aspirations, go to law school and pass the patent bar, and then call yourself a patent attorney. There are plenty of attorneys who work in intellectual property that are not necessarily patent attorneys, and we'll talk about what that means to be a patent attorney or a patent agent with respect to what you can do within the world of intellectual property. Being an attorney does require going to law school, which I've heard either is a horrible, horrible 3 years, or a really lovely 2 years, and then a really horrible third year, because by that point you're really ready to get out. Or some people thoroughly enjoy all of law school, all 3 years, and then hate the practice of law. Because law school is so very expensive, you should do some diligence before you jump in. And so, for example, I will tell you that I've been paying attention to the front page of the Wall Street Journal that has spent a lot of time talking about the glut of attorneys on the market. There are a lot of people who thought, wow, the economy is really bad. I know what I'll do. I'll dive into some professional school. I'll dive into an MBA program. I'll dive into a JD program. When I come out, I'll have more skills, letters after my name, and people will be more willing to hire me. Unfortunately, so many people made that decision that you can now pick and choose. And the number of jobs that are available for new JDs is really low. So I saw, even in the time that I was at the law firms, our summer class used to be massive. When I first started at the law school, at the law firm, I wanted to be a summer associate because at these fancy law firms, they get wined and dined for the summer. They go to the partner's house for drinks. They go sailing in San Diego Bay. They get sent down to Cabo San Lucas. It was like, at some point they had to work. I've got to imagine, but I didn't see it. But that class went from being like 50 warm bodies every summer that we were bringing in to like 10. And this was a snobby law firm, so they were only taking top-tier lawyers, law students, coming out of top-tier law firms. And so the trickle-down effect, there's 40 extra bodies in the next tier that are like, and then you can imagine it expands exponentially. So when the opportunity came for me to consider going to law school, I was like, I don't think that's such a good idea. For a number of different reasons, one of which is I now have 2 children. So I decided to start a family instead of going to law school. You don't have to make that decision. So let's talk about what it means to be an attorney versus an agent. So an attorney, law school, you've passed the state bar in each state that you want to practice. So these poor folks that grew up in California and passed the bar in California and decide really what they want to do is live in North Carolina, they have to move here and pass the North Carolina State Bar. There are states that have what's called reciprocity, where if you pass the bar, for example, in North Carolina, Virginia might say, okay, fine, you have accreditation, or whatever it's called, to practice in Virginia. California's a bit snobby, and they don't have reciprocity with anybody. They don't let anybody come in and start hanging out a shingle and saying that they're an attorney. You've got to pass the California State Bar. It seems to me a huge hurdle then to consider crossing state lines when you have to pass the state bar again. And there are certainly examples of people who have been unsuccessful at doing that, and what they do is somehow convince the place that they're employed, it's really not necessary for me to be registered to practice in this particular state. I'll just keep active the bar, the standing that I have in this other state. And sometimes that works and sometimes it doesn't. So an attorney does what I've called here prosecution, and that is the bickering with the U.S. Patent Office. That is the drafting, meeting with an inventor, figuring out what the invention is, drafting that invention in a document called a patent application, sending it in, signing off, saying this is a patent application, we want you to someday consider it. When the patent examiner looks at it for the first time, you start the bickering process back and forth about the scope of the invention, whether it meets all the statutory requirements, which you have to know because you passed the patent bar, whether it's enabled, whether it's non-obvious, whether it's novel, whether there's written description, whether it has utility. All of these are questions that have reached and been bickered about even up at the Supreme Court. So people care about these standards, and you have to be able to argue that the invention that you captured has all those requirements in there. So that it means that when you're drafting the application, you better be paying attention to how the law is changing, so that by the time your application gets in front of someone, they don't go, well, there's this new thing, and you didn't include anything about this new aspect of law, therefore we're not going to give you or your client a patent claim. You can also do litigation. That means you can litigate just about anything, but in the intellectual property world, that means that you can take your client's patent and write a letter to someone and say, we believe that you might be infringing this patent, and we think that you should pay our client a license for the privilege to continue to practice whatever invention, be it a method of making something, a method of doing something, selling a widget, buying a widget, that sort of thing. So if this potential licensee says no, then you get to sue them for patent infringement. Patent infringement is a wildly expensive proposition. It's like $1 million just to call up an attorney and say, I want to sue someone for patent infringement. And so while a patent can be very valuable, you need to have fairly deep pockets to make it a useful business tool. And the company litigations can run to the tens of millions of dollars easily, without even thinking about it, tens of millions of dollars. You can imagine the recent, and now it's not quite so recent, the Samsung v. Apple litigation, right? The award was $1.04 billion. Can you imagine how how much legal fees it cost to get an award of $1.04 billion? So again, if you're going to be a patent attorney and be involved in litigation, there is a skill set you need. You need to understand patent law. You need to understand licensing terms so that you know when to and how to negotiate. So you need to have some familiarity with transactional law and contracts and things like that. You also need to be fairly persuasive in a court of law, because you either need to persuade the judge who's sitting in on some of the early decisions, or a jury. You need to be able to distill the technology that can be very complicated, right? Samsung's argument was Apple was infringing patents that had to do with the connectivity, and forgive me if I'm wrong, but it was something about the communication. So there was a network and the communication to the individual devices, and there was some method of communicating that Apple was infringing. Apple's argument was, see that pretty corner on Samsung's phone? That's our pretty corner. You can imagine which argument was easier to communicate to a jury of people they pulled in off the street, right? So you need to think about how to distill sometimes very complex technologies, or pick your battles so that your argument is, see this pretty corner? Doesn't it look like our pretty corner? Done. The transactional work I mentioned, that is involved in licensing technologies to companies that are interested in using that patent or want to be assured that they're not going to get sued for infringement. It also includes doing mergers and acquisitions where you do diligence on the intellectual property, who properly owns it, what technology does it cover, does it matter to your business interests whether they have that patent or not, what's the relative strength of it relative to the opportunity for the patent to be shown to be invalid. I often would get, well, I'll tell you what I got in just a bit. If you're an attorney, generally the trend is up or out. So they bring in a whole bunch of first, second, third year associates, right? And they put you to work mad hours, and they see how you do. And those that don't do so well leave. And then the next year it's a little fewer people, and a little fewer people, and a little fewer people. By the time they're ready to make you partner, you have to have a business argument for them to hire you. I mean, to keep you. You need to have clients that are willing to pay $500–600 an hour for you to think deep thoughts for them. You need to have the opportunity to work collaboratively with other partners to grow your business. It's most like any other businesses. But it's up or out, and that can be very stressful for mid-year associates, mid-level associates, and higher. So as a patent agent, you can do that bickering with the patent office that I talked about. You can meet with the inventors, you can draft patent applications, you can bicker, that is, the patent office sends you an office action saying you can't have a patent claim. You write back and say, of course I can, this is why, here's the case law that supports my argument, or I've amended my claim language because I missed some of the statutory requirements and I'm going to tidy things up. You can do litigation support, but you are not an attorney, so you do not get to stand up in front of a court of law and make any arguments. You can sit there taking notes. You can certainly be, as you would with your technical background, a technical expert, to the extent that you work with real experts. So while I have a PhD in chemistry, and there were certain aspects of technology that I felt fairly comfortable talking about, the court doesn't want to hear what I have to say. The court wants to hear what an established researcher who has 20 years of publications in this space and has a CV that's fairly robust and is getting paid $500 an hour as a consultant to weigh in with his or her expertise on some technology matter that's before the court. So litigation support when you're a patent agent often means things like document review. This is not nearly as glamorous as it sounds. Document review may sound like you look at a piece of paper that the other side has submitted and you figure out whether it's relevant to the patent litigation case that you're working on. And if it is relevant, how relevant is it and which subject matters is it relevant to? Yes, that is document review. And then you do that a million times. Now, wonders of modern technology, they are doing things like scanning documents and doing optical character recognition and doing word capture so that any time Laura Collins is the inventor name. So let's just do an electronic search, and anytime Laura Collins' name comes up in a document, we're going to pull that. And other useful words. Infringing might be a word that you want to search for example. So some of that is being automated, but you still need a set of eyes to look at scads of documents. And patent agents don't bill out at the same rate that patent attorneys do because we haven't gone to law school, and so we are always cheap. The last bullet point then is that we will not price ourselves out of a job. There is no up or out. When I started working for the partner that I was employed by, I was a scientific advisor. When I got out, I had made it to patent agent because I had passed this exam. But for 8 years between passing the exam and getting out, I went from being patent agent to being a really good patent agent. I mean, that was it. There was no sort of room for promotion or improvement because I didn't have the law degree. Now, for me, that worked for the time that I was going to be. But I read some review about, like, how do you know when your career is dead end? And one of them was there's no opportunity for promotion. So I went to my boss and I said, hey, this is me. And she was like, oh, you're fine. Go away. And she was right, because in the 10 years that I worked with her, I got to do a lot of fun things, some of the more litigation-friendly kind of things, working with experts, those technical experts, drafting reports, that I was able to do because she had mentored me and she taught me how to do things, and not that anyone else was going to let me do because I didn't have the JD after her name. So your form of counseling when you're doing intellectual property counseling for clients is often landscape review. And what that means is you go into the scientific literature, you go into the patent databases, and you say, okay, this is where my inventor's technology is. What does the technology space look like all around that? That is, how greedy can I be? So if he tells me his invention is this big, can I be a little greedy and say, well, no, really, there's nothing else near you, so I can make a claim that's like this big. But if there's something right smack dab in the middle of what he says or she says is her invention, then you go back and you say, no, let's not spend the $10,000 to $50,000 it takes to get a patent. Stop now, cut your losses, go and do some more research and find some space that isn't already used by someone else, or maybe isn't as crowded, where there's a lot of activity going on in a particular technology space. And then prior art searches. So one of the things that you can do when you're a litigation support is there is an invention that is claimed, and your client is being sued for infringing a patent. And what they say is, okay, I need to show that this company should never have gotten this patent in the first place. So I need you to go to the library every day, all day, and don't come out until you find either a journal article or a prior publication or a patent that shows that someone else thought of that chemical compound, for example, or thought of that method of treatment, or thought of that widget. And so you can spend, I have, a month straight at the biology library at UCSD's campus and do nothing but look through journal articles as long as you can to find something that you can put together as an argument to say that this patent should never have been issued. Then you hand it off to the partners and they figure out whether that makes a good argument, a good story to tell the judge, a good story to tell the jury, a good story to put in front of the owner of the patent to say, I know you want a license and we're going to give you this shiny nickel. And we're going to show you this list of references, and we're going to ask you to step away from the table with just this shiny nickel, because your patent isn't really worth anything more than that. Now, that's a strategic argument. Patent agents don't get to decide what goes on at that table. You just provide the information. And the attorneys, who, sometimes I said $500. I thought, I met one guy who's billing out $1,000 an hour. He gets to decide whether or not what the argument is.